So we just got some bad news out of the Supreme Court. The Supreme Court has denied review to the Snope rifle ban case and the Ocean State tactical magazine ban case. This was a frustrating order and decision by the Supreme Court, so we need to break down what the judges decided to do, what they said about their decision, and the claimed reasons about why they denied this case. Now, before we jump into this video, if you want to support the channel for free, please consider subscribing to the channel. That, of course, helps the channel to grow. And then just drop a positive comment down below because that tells the algorithm that you appreciate 2A content and it should share it to more people. As I mentioned in the intro, in this video, we just got some big news out of the Supreme Court. Today, the Supreme Court has issued the order and they denied review to the assault weapon and magazine ban challenges that were in front of them in seeking review. The cases we're going to be talking about are Snope versus Brown and then also Ocean State Tactical. These are the two cases that have been relisted 15 plus times, and we were all curious about what the Supreme Court was doing and ultimately what they would decide to do. Well, today we found out that despite having relisted these 15 times and despite having, 6 claimed conservative judges and the majority on the Supreme Court, they couldn't even get the 4 votes to grant review to these cases. It appears there was a 3-3 split when it came to conservative justices on the Supreme Court on this issue of rifle and magazine bans. Only Thomas, Alito, and Gorsuch were in favor of granting review to these cases. However, I believe Roberts, Barrett, and Kavanaugh were in favor of denying review to these cases at this time, and ultimately it was the side that did not want to grant review to these cases that won out because they, of course, had the liberal justices join them in denying review. Now, this split in camps is reflected also in the opinions in the dissent attached to this denial order in the Snope case. It appears you really have Kavanaugh writing a statement on behalf of the justices who denied review in this case, and then you have Thomas writing for the dissenting opinions, the camp of Alito and Gorsuch who wanted to grant review to these cases. The 3v3 split is potentially also why we saw this get relisted so many times. There might have been a long discussion trying to win over maybe Kavanaugh or Barrett to the side of granting review, but ultimately they denied review in this case. So let's break down why Kavanaugh said their side decided to deny review to these cases, and then we're going to talk about what Justice Thomas said about that other side and why he believes they should have granted review to this case. Now, the denial order states that the petition for a writ of certiorari is denied. Justice Alito and Gorsuch would grant the petition for a writ of certiorari. And then there was a statement from Justice Kavanaugh respecting the denial of the cert, so essentially explaining why he denied cert and maybe why his side decided to not review this case, and then there was a dissent by Justice Thomas. Justice Kavanaugh in his statement states that in DC versus Heller, the court ruled that the Second Amendment must be interpreted in light of the constitutional text, history, and tradition. The court further determined that the Second Amendment protects those weapons that are in common use by law-abiding citizens. Because handguns are in common use by law-abiding citizens, the court held that the District of Columbia's ban on handguns violated the Second Amendment. The court's later Second Amendment decisions in Bruin and Rahimi did not disturb the historically based common use test with respect to the possession of particular weapons. This case primarily concerns Maryland's ban on the AR-15, a semi-automatic rifle. Americans today possess an estimated 20 to 30 million AR-15s. The AR-15 are legal in 41 of the 50 states, meaning that states such as Maryland that prohibit AR-15s are something of an outlier. Given that millions of Americans own AR-15s and that a significant majority of states allow possession of those rifles, petitioners have a strong argument that AR-15s are in common use by law-abiding citizens and therefore are protected by the Second Amendment under Heller. If so, then the Fourth Circuit would have erred by holding that Maryland's ban on AR-15s complies with the Second Amendment. Under this court's Second Amendment precedents, moreover, it can be analytically difficult to distinguish the AR-15 at issue here with the handguns at issue in Heller. AR-15s are semi-automatic, but so too are most handguns. Law-abiding citizens use both AR-15s and handguns for a variety of lawful purposes, including self-defense within the home. For their part, criminals use both AR-15s and handguns as well as a variety of other lawful weapons and products in unlawful ways that threaten public safety. But handguns can be more easily carried and concealed than rifles, and handguns, not rifles, are used in the vast majority of murders and other violent crimes that individuals commit with guns in America. In short, he stated, under the court's precedents, the Fourth Circuit's decision is questionable. Although the court today denies certiorari, a denial of cert does not mean that the court agrees with the lower court's decision or the issue is not worthy of review. The AR-15 issue was recently decided by the First Circuit and is currently being considered by several other courts of appeals. The opinions of other court of appeals should assist this court's ultimate decision-making on the AR-15 issue. Additional petitions for cert will likely be before this court shortly, and in my view, the court should and presumably will address the AR-15 issue soon, in the next term or two. So Justice Kavanaugh and his camp's kind of position can be best summarized as, yeah, this is a big issue. Maryland got this wrong. It does not align with Heller or Bruen or Rahimi, but we don't want to review this right now. We're going to let the lower courts continue to review these cases. Maybe in a term or two, we're going to address this issue, but just not right now. We don't want to look at it. Now, some commentators might point to this as a good thing, but really, it's just an empty promise at this point being made by Justice Kavanaugh. He can say that they're going to review this issue in a term or two, but there is no guarantee that the Supreme Court will fulfill that promise in any future review or cert petition, especially if the makeup of the court ever changes. And God help us if Justice Thomas or Alito decide to retire, then really any promise is off the table. Now, the criticism of Kavanaugh and his camp denying review to this case is echoed in Justice Thomas and his dissent. Thomas claims that this court has made the Second Amendment a second-class right once again, and that their inaction and recent decisions in cases like Vanderstock have opened up gun owners to more attacks by the federal government. Thomas in his dissent states that I would not wait to decide whether the government can ban the most popular rifle in America. That question is of critical importance to tens of millions of law-abiding AR-15 owners throughout the country. We have avoided deciding it for a full decade, and further percolation is of little value when lower courts in jurisdictions that ban AR-15s appear bent on distorting this court's Second Amendment precedents. He stated that I doubt we would sit idly by if lower courts were to so subvert our precedents involving other constitutional rights. Until we are vigilant in enforcing it, the right to bear arms will remain a second-class right. He went on to state that the constitutional status of AR-15s is all the more urgent after the Supreme Court's decision in Bondi versus Vanderstock. Recent amended regulations of the ATF provide that a firearm under the Gun Control Act includes objects that may be readily be completed, assembled, restored, or otherwise converted to a working firearm. In Vanderstock, this court refused to hold the definition unlawful, reasoning that an artifact noun, that is a word for a thing created by humans, may refer to unfinished objects, and thus that weapon parts kits are as regulable as the firearms they might eventually become. But every single AR-15 can be converted to a machine gun using cheap, flimsy pieces of metal, including coat hangers. Until we resolve whether the Second Amendment forecloses that possibility, law-abiding AR-15 owners must rely on the goodwill of a federal agency to retain their means of self-defense. That is no constitutional guarantee at all. So Thomas points out that the denial here simply reinforces that the Second Amendment is treated like a second-class right. The claimed percolation that the other justices want to happen really amount to just lower courts like the 7th Circuit, 9th Circuit, and others continuing to twist and directly defy Bruen. And really nothing stops them from doing that because the Supreme Court, in Thomas's own words, is sitting idly by, doing nothing, and kind of allowing this. Kavanaugh instead says everything is okay. They will take review of the rifle ban or magazine ban, maybe in a term or two. They're just not going to review it now. They want to get more information from lower courts. However, in my opinion, that's kind of not convincing at all. Kavanaugh points to cases like ANJRPC in the 3rd Circuit, Barnett in the 7th Circuit, Miller in the 9th Circuit, all of those cases that we're going to be watching. However, we know exactly how those are going to play out. So why are they waiting for them to issue those decisions when we know that they're going to rule the same way that the 4th Circuit did? Kavanaugh said that a denial of certiorari does not mean that the court agrees with a lower court decision or that the issue is not worthy of review, but really in many ways, that is exactly what the Supreme Court is kind of continuing to signal to all these lower courts. Now, ultimately, what's going to happen after this dissent and the opinion here in the denial, you will have both sides, the anti-gun side that will cite to the denial here saying that that supports their rifle bans and magazine bans, and then you're going to have our pro-2A side pulling language from Thomas's dissent and even Kavanaugh's statements saying that AR-15 bans and magazine bans are clearly unconstitutional, but none of those are binding precedent and really does nothing to move the needle, so lower courts will continue to do whatever they want, and it's not until the Supreme Court steps in that anything will actually change. So unfortunately, that's just what happened in the critical rifle and magazine ban cases that were pending in front of the Supreme Court. We're not going to have to shift focus on other cases like Duncan, Miller, ANJRPC, and others. However, I have little confidence the Supreme Court will ultimately decide to grant review to any of those cases or any of that will change. So that's what just happened in the denial. That's the statements that were made by Justice Kavanaugh, kind of for the camp that did not want to grant review to these cases. And then that's also what Thomas said, kind of for the camp that wanted to review this issue now. So if you guys have any questions, go ahead and comment down below and I will try to answer to the best of my ability. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And don't forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.